Can the government use infrared scanners to peer into a suspected criminal's home without a search warrant to gather evidence of his crimes? That was the question in the case of packing too much heat. In this case, federal officers had information that the suspect was growing marijuana in his home, but lacked enough evidence to obtain a search warrant. Growing marijuana indoors often requires heat lamps, so the government agents procured a thermal imaging scanner to see if certain areas of the house gave off intense heat. The agents scanned the suspect's home from a public street and found that the suspect's garage was substantially hotter than the rest of the house. Based upon tips from informants, utility bills, and the thermal imaging scan, the agents obtained a search warrant for the home and found over 100 marijuana plants growing in the garage. The suspect challenged the government's use of the thermal imaging device, alleging that the scan was in fact an unreasonable search of his home in violation of his Fourth Amendment rights. How would you decide this case? Can the government use infrared scanners to peer into a suspected criminal's home without a warrant to gather evidence of his crimes? We'll be back in a moment with the answer to that question. Can the government use infrared scanners to peer into a suspected criminal's home to gather evidence without a warrant? No, according to the United States Supreme Court. The court agreed with the homeowner that the scan was an unreasonable search of his home in violation of his Fourth Amendment rights, which states, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, except for a few situations. For example, if the homeowner gives permission to search, the government needs a search warrant to conduct a search of one's home." Remember, it's a matter of law.